Thank you. It's really a pleasure of mine to be here this evening. My name is Hemingway, and I'm with the Missouri Department of Economic Development. A number of the programs that Brian described fall under the division that I manage in the department, as will the Distressed Areas Land Assemblage Tax Credit Program. That program will fall under my division. So I'm happy to explain to you or have a discussion with you this evening about how we interpret the legislation and how we will actually make a program complete with applications and application process and everything out of this. I prepared a handout, so most of you received it. If not, I'd be happy to share it with you. If you want to leave me your email or your name, telephone number, I can certainly get it to you. It's really a question and answer that's titled the Distressed Areas Land Assemblage Tax Credit Act. And it goes through, and if you'll beg my indulgence here, I will actually kind of ask the question and then respond to the question in the best way I know, based on what's found in the legislation, in the bill, in House Bill 1 that was just recently passed. This will take effect 90 days from the date the governor signed it, so 90 days from September 4th. We have to have the application prepared, and the actual legislation will take effect. So who may apply for the land assemblage tax credit? Eligible applicants are any person, firm, partnership, trust, limited liability company, or corporation which has met the following two components. One, they've incurred an acquisition cost inside an eligible area, and we'll discuss what an eligible area is in a few minutes. And two, they've been appointed or selected by the city, by the municipal government, as a redeveloper and designated to receive economic incentives after the city has considered the amount of credits. They have to, in other words, redevelop the property. This is not solely a land assemblage tax credit, and then once the land is purchased, they're done. They're tied to, as a result of receiving the credit, they're tied to redeveloping the property as well. So the end result, or the benefit, or the gain for the state and for the community is that that land is actually redeveloped and put back into use. Some of the restrictions that are placed on any applicant are that, one, they may not be the sole developer of any redevelopment area. Typically, cities choose redevelopment areas and create redevelopment plans, and those redevelopment areas are designated by a geographic boundary. If you're an eligible applicant and you've been designated the redeveloper for that area, you cannot be the sole redeveloper for that area. You may acquire the property, however, you may not be the sole redeveloper. In other words, you can only, the law specifically states that you can only, as a developer, redevelop 75% of the area. You have to share at least 25% of it with another developer. So that limits the ability for one person, one firm, one entity to take control over any one redevelopment area. And a city or county may have a number of redevelopment areas that they're interested in pursuing. Another restriction that's placed on the applicant is, as I said, they have to redevelop the land in order to receive the tax credits. They must comply with the redevelopment agreement that they've entered into with the city. That is a legal document in which there is a give and take between the city and the developer. And the developer who's receiving these tax credits has to comply with every one of those redevelopment agreements. And then finally, they're subject to prevailing wage law. In other words, if they receive these tax credits and they work inside a redevelopment area, they have to pay prevailing wage to be eligible to receive the tax credit. The law specifies what an eligible parcel is for purchase as well. It describes what a parcel is, and it has to be located inside an eligible project area. We're going to talk about, the senator described a little bit about the components of an eligible project area, and we'll discuss that in a moment. But the eligible parcel for purchase has to be located inside that area. It has to be intended for redevelopment. It has to be acquired without the use of any condemnation proceedings. If you want this tax credit, you cannot use condemnation in order to gain access to the property. It has to be one on which no construction has started. In economic development, when we provide an incentive for a developer to do something, we often look for what's known as a but-for. And a but-for would mean literally that they couldn't have started the project before we provided the incentive, because what good would the incentive have done? If they're able to go ahead and do that, then there's really not a place for the state or the locals to provide incentives. What we're trying to do is provide incentives where it's not feasible for them to accomplish a task that's agreed upon in a redevelopment agreement. So here, we're looking for properties that have not had any construction on them at all, on which no construction has started. And also, an eligible parcel is one that has no outstanding taxes, fines, or bills levied by the city. If there's an outstanding tax on the property, it's not eligible for accessing this tax credit. It's the same with bills or fines. An eligible project area, then, is made up of all of those parcels. And the project area consists, as the Senator said, of at least 75 acres. 80% of those 75 acres shall be located within what's known as a qualified census tract or a distressed community. When we create the eligible application, actually before that, we will post up on our website maps of the entire state of Missouri that show eligible qualified census tracts and distressed communities, so that you'll be able to determine whether or not your parcel falls within one of those requirements of an eligible project area. So 80% of the properties have to be inside the qualified census tract or a distressed community. An eligible project area is also one where the applicant has purchased at least 50 of those 75 acres. So they have to be predominantly purchased by this developer. It's also one where it's defined with an average number of parcels per acre of 4 or more. So there have to be average number of parcels per acre have to be 4 or more parcels per acre. And it has less than 5% of the acreage consisting of owner-occupied residences. So what are they looking for? If less than 5% of the acreage consists of owner-occupied residence, they're really looking for vacant structures, vacant property, those types of things. Large parcels of property that they want to acquire for redevelopment. The tax credit then has several different types of values. Okay? The total aggregate amount authorized under this program cannot exceed $95 million. So that's the total of the program. It has a cap. Many of our tax credit and grant and loan programs that we administer in the department are set with caps, and this one has one at $95 million. We cannot issue more than $10 million of tax credits in any one year. So it's controlled, and the control feature is for budgeting purposes. If we're issuing only $10 million a year, we can pretty much guess what the cost against the state budget will be. The tax credit has a value, an individual value of 50% for land acquisition and for 100% of interest carry for up to a 5-year period. And the tax credit is sellable and transferable, meaning that if we issue to a developer for an eligible parcel in an eligible area a tax credit, that developer may sell or transfer that tax credit and gain cash so that they can help offset the costs of their development, of their acquisition costs and their redevelopment costs. Many of our tax credits that are administered in the department are sellable and transferable. Acquisition is also defined in the statute, and it's made up of the purchase price for the property, costs of environmental assessments, closing costs, real estate brokerage fees, reasonable demolition of vacant structures, and reasonable maintenance of costs for up to a 5-year period. What's not included, or what we cannot issue a tax credit for, is the cost of title insurance, surveys, attorney's fees, relocation costs, and fines or bills from the municipality. If an entity is fined or billed from a municipality, we cannot issue a tax credit to pay for that fine or bill. So those are the components of the legislation. And as I said, in the next 90 days, the department will be putting together an application and accepting applications from not only eligible developers or eligible applicants, which we listed in the first question, but also on eligible project areas for eligible parcels. And all of that has to be clearly spelled out and complied with. Okay? I too will be happy to answer questions whenever